Hello everyone, I'm Catherine Henry, attorney here in Michigan. We're going to go ahead and, well, I'm not going to worry about it. If my phone makes sounds, it makes sounds, that's fine. So I'm going to do a series of small little videos for you today to try to address some of the concerns and comments and questions that people have been asking me about various legal aspects involved with what's going on. So the first little blurb that I'm going to put out here today is questions regarding recalling or removing any governor from Michigan. So first, one of these basic concepts of law that I have not, I have taken for granted, and so I have not focused on or emphasized enough in videos to you guys as the public, is the concept that we do have laws on the books. Of course, we have a statute. We have, you know, our laws, our statutes, our Michigan codified laws. We have a state constitution. We also have a United States Constitution. Those are the three main sources of governing authority, of legal things that I've been referencing in all of my videos to you in the legal documents I've put out. The main thing to keep in mind, though, is that nothing in any of the statutes I talk about, or in any statutes at all on the books, nothing in a statute can supersede or change something that's in one of the constitutional provisions. So if a statute says it's okay to violate anyone's right to speech as long as it's on a Saturday and not on a Sunday, doesn't matter if that's what the statute says, that's not what our Constitution allows. So kind of a silly example, but just something I wanted to explain, that the underlying themes here, no statute can be enforced in such a way that would violate the terms of our U.S. or Michigan constitutions. So with that being said, I'm going to roll right into the issues about governor here. So our state constitution of 1963, Article 2, Section 8, is the provision governing recalls. So in here, Article 2, Section 8, it's actually a very short section. It basically calls for 25% of the number of people that voted in that particular area in the last election for the office of governor. That is the number of people that would be needed to sign on to a petition to initiate recall proceedings or initiate a recall election against any elected official. So that's the basis of doing recalls. That's Article 2, Section 8 of our Michigan Constitution. Then we have the Michigan Election Law, which is an act. It's actually Act number 116 of 1954. Specifically, Chapter 36 deals with recalls. MCL 169.975A, 169.975C, E, and G. Those four are the specific statutes on point when it comes to recalls for the specific office of governor. So, in short, you essentially, if you want to recall the governor, you have to submit the reasons why you are doing so in a statement of 200 words or less. The governor actually gets to has the opportunity to include a justification for those actions, which would also be in a statement of 200 words or less. And should the question then ends up being on the ballot, assuming the requisite number of people have signed a petition, the question on the ballot would be, shall Gretchen Whitmer be recalled from the office of governor, yes or no? So those statutes really go to the specifics of every little step along the way. The statutes also require there to just be a simple majority for the recall to go through. So if you have 100 people that vote in that election and 51 of them vote to recall her, then she would in fact be recalled. Then the law works with or refers back to the other provision in our Constitution, which treats the recall of a governor different than the recall of any other like local office or a city council member. A lot of people around Michigan have experience with recalls for a variety of local offices, but our provisions in law are different for those than they are for this one particular office, the office of governor. So, Article 5, Section 26 deals with succession to governorship, and it states that basically if the governor is convicted on impeachment or just removed from office or resigns or dies, basically is no longer able to serve in that office, then the lieutenant governor would be in the next in line, and so the lieutenant governor would be serving as governor for the rest of that term. If the governor is unable to serve, then it would go to our Secretary of State. If that person is unable to serve, it would go to our Attorney General. So, again, that's Article 5, Section 26 of our state constitution. That's not like any other recall that we really have anywhere else in Michigan. So I just wanted to bring your attention to that because a lot of people have been calling for the governor's recall, want to remove her from office. My caution to you would be, if you are someone who wants to remove the governor from office, would you be prepared for or wanting the lieutenant governor we currently have to move up into that role of governor? If you don't want him to be the governor, then any kind of recall effort or impeachment proceedings would be fruitless, because that is the result you get from our state constitution. So that's basically the only thing I wanted to tell you guys, but it looks like we have a couple questions. So the question is, what is the process for removing the Secretary of State and the Attorney General? I did not specifically look for that ahead of time, but my understanding is that at this point, that would be the same recall process. That would be, in fact, if you give me 1 second here, I might be able to see if there's something in our law that talks specifically about those positions. Okay, I'm not seeing any within that recall chapter of our election law that specifically talks about those offices being recalled. We have a section 168.959 that talks about the recall of senators, representatives, state officers, county officials, Secretary of State. So that would include those situations. We have a different statute, 168.960, that is for the recall of elective county commissioner or township, city, village, or school officials, recall of elective district library board members, and elective metropolitan district officers. So there are a few nuances depending on the type of office, but in general, it's going to be more along the lines of the traditional approach that people think of in Michigan for recalls. It's not covered under this particular provision in our Constitution. Can we... the next question is, can we vote you as our governor? I suppose so, but that would be at the next gubernatorial election here in Michigan, and I don't really plan on running for governor. But I guess if God calls me to do that, then I would follow the call. At this point, thank goodness, He is not calling me to do that. Didn't Snyder change change some things up. So Snyder can't change, I don't know if the question was getting at the ability to do recalls or specifically recalling in the office of governor, but the governor can never change anything that's in the Constitution, nor can the governor ever change anything that's in our laws without it going through the actual legislative process. Kind of funny, that's actually what's happening here with our executive orders. The governor's not allowed to change anything in our laws without it going through the traditional legislative process, but that's a video for another time. So hopefully that answers your question. There's nothing that Snyder could have done to change the provisions that we just talked about. So again, this is just a short video meant to educate people on what our constitutional provisions and statutory provisions are in Michigan for recalling or removing someone from the office of governor. I'm not advocating for or against removing or recalling her. I'm just asking you guys to seriously consider, if you want to remove her from office, you need to be prepared for what the Constitution says is the person that would be replacing her. So just keep that in mind when you're making your decisions about how you want to be politically active in dealing with what's been happening now. So thank you.